Imagine you're walking into a biggest startup stage in India and you are actually pitching in front of some of the powerful investors, and the investors are getting impressed and they fund you with 70 lakhs. So you were on a national television in front of millions of viewers and the company becomes highly popular. But suddenly this company gets a court notice stating that they should not manufacture, they should not package, they should not sell, they should not distribute their products. Do you know why? Because on the national television, the founders of the company made one sentence, and this one sentence destroyed the company's worth overnight. This is a story of Bisleri versus Aquapeya, and this case was the most discussed case of Trademarks 2025. And in this video, we are going to discuss about 5 important business lessons along with the legal lessons which every business entrepreneur should learn. Myself Rohini, your corporate lawyer from Intelligensia Private Limited. Before going into this discussion, I would like to mention that if you are an entrepreneur who are going to start the business or have already started the business, we have created a WhatsApp business community to clarify all your legal doubts. If you want to join our community, kindly click on the link in the description and join now. Now let's start about how the brand Aquapeya became so popular. Our story starts in 2018. In Maharashtra, there were 2 entrepreneurs called Ravi and Tushar. They joined together and formed a company name called Aquapeya, and this company is into business of packaged water bottle. Their business model was smart. They did not opt for B2C business, they opted for B2B business. They did not sell their product to customers, instead they were selling it to hotels, restaurants, and they were taking only bulk orders to corporate people. So this business model actually survived very successfully, and after many years in 2025 this company wanted to scale up and they applied to Shark Tank India, and in January 2025 this company Aquapeya made a very good pitching before the investors of Shark Tank India and also successfully were able to get a funding of 70 lakhs from 2 investors, mainly Namita Thapar and Ritesh Agarwal. These 2 sharks actually really liked the business model of B2B. For every startup, this is actually a dream. On a national television, investor funded this company in front of millions of people. This increased the credibility of that company. But what went wrong in this case? Aquapeya's founder made one sentence during the pitch, and this sentence invited a legal case from Bisleri against them. What was the sentence? During the pitch, the Shark Tank judges actually asked the founders of Aquapeya that your bottle looks with a similar color of Bisleri and also with a similar design. Now to this, the founders answered stating that yes, many people are identifying a packaged water bottle with green color and they are also identifying with a similar design. So inspiring from them, we also created a similar water bottle. This one single sentence proved the intention of that founders, and it became a single admission in front of whole of the media. Under trademark law, there is one important point where what is the intention of the person who is making a trademark infringement. In this case, the intention is clear that they have copied the Bisleri knowing that the Bisleri is already popular. Using this advantage, Bisleri actually filed a case before Bombay High Court. They made 3 important charges against Aquapeya. The number 1 charge is trademark infringement using the same type of logo and color on the label. Number 2 is passing off. The overall impression of Aquapeya brand actually made the customers confused. Number 3 is copyright infringement. The artistic work and design in that label has also been copied. This is called pirated work. Now Aquapeya actually made a strong defense against Bisleri. Aquapeya actually stated that the 2 companies are not even in the same market because Aquapeya is not selling its product on any supermarket or to a customer. It is only selling it to B2B market like a hotel or restaurant, and their customers are different from Bisleri customers. Now as per Trademarks Act section 29 and 22, if there is any customer confusion, there should be a proper proof of confusion. Listening to both sides' argument, Bombay High Court stated that though both the companies are not in the same market, but Aquapeya made an open declaration in national television that they intentionally copied the Bisleri's identity. And this proves the bad faith of Aquapeya to copy the customer identity of Bisleri. And hence, Bombay High Court gave an interim injunction stating that they have to immediately stop using this brand and stop manufacturing this packaged water bottle. Now, from this case, every business entrepreneur should know these 5 business lessons. The number 1 lesson is the Aquapeya actually inspired from Bisleri. They created a logo. For an inspiration, there is no limitation. But if your inspiration is amounting to an infringement or copying someone else's brand identity, then it becomes a legal suicide. Number 2, everything we say in public is a legal evidence. For example, if you are making any post in social media or making any video in YouTube or doing any other public statements, all these can be used as evidences. So every entrepreneur must be careful when they are promoting their brand. Number 3, a thorough trademark search. Every brand owner must not just make a trademark search for name, but also for the logo, the color, and also the design that they are using in their brand. This thorough trademark search will actually help them avoid any future legal problems. For making a trademark search, kindly don't make it on your own. Approach a lawyer or an expert in this field and make a thorough search. If you are going to make a thorough search, 99% of your legal problems can be avoided in future. Number 4 is, we all think that trademark is only for the name or logo, but nowadays trademark can be obtained for a color also. If you are building any unique color and if your color becomes the customer's identity, then you can protect that color itself for your brand. Number 5 is, investor funding will not lower the risk. For example, in Aquapeya, they got 70 lakhs funding with a valuation of 23 crores. But this 70 lakhs did not save them from any law risk that they have faced. So as a business owner, whenever you are taking a funding, first you should be responsible for that funding by making any original product with original logo and not copying any other brand. Now, Aquapeya founders were really very good entrepreneurs. They really worked hard. For about 7 to 8 years, they were building their company, but one simple sentence on a national television became the biggest blunder for their own company. So always not just protect your company from the business point of view, you should also think about what are all the legal risks your company could face because of brandings. That's why as an IP lawyer, I would suggest make a thorough trademark search and protect your brand as early as possible. From this case of Bisleri versus Aquapeya, what do you think? You can mention in the comment box. And also, if you are facing any legal issues due to your branding or trademark, kindly call to this number and get your consultation today. Like this, more useful video will be posted in our channel. Kindly subscribe to our channel. Myself Rohini, your corporate lawyer from Intelligensia Private Limited.